Hello, good evening, and a very warm welcome to all of you today. We are back again with another session on the current affairs of your legal, um, you know, um, legal area. Now, what we are going to be talking about today are the legal current affairs from 16th of January to the 31st of January. We are going to be discussing the important judgments, any new bills and acts, and any important events that have taken place in the country or internationally in the legal field. I am Jodhpreet, law expert at HitBullsEye, and I welcome you all in today's session. Let us quickly begin with the current and most important judgments that have come in the second half of January. Starting with now, very first, this is Sushil Kumar versus State of Haryana. Now, in this present judgment, what had happened was a police official, he had said and he had asked and requested for a retrospective promotion. What he had said was that his name was introduced in the list of promotions in the year 2004, where it was cancelled out, and then later on in 2008 he finally, upon a reintroduction of his name, he finally gets a promotion. He says that his promotion was due all the way in 2004 and it should be given a retrospective or a backdated effect. However, now in this case what had happened was the judiciary looked upon the procedure of the way he had gotten the promotion. When he got that promotion, it was seen that his promotion was given to him or granted to him in a reasonable manner by proper procedures, and there was no sort of a wrongful activity in that procedure. Upon the judicial review of this, the Supreme Court says that we will not only look at the final decision in a matter, but what's really important and relevant for us is the way or the procedure that took place to get to that decision. So the judicial review is not only going to deal with the aspect of the final decision of any procedure or any aspect, but it's going to look at the whole procedure step by step, whether it was validly done or not. In this case, the Supreme Court was satisfied that the whole procedure was correctly done, and in this way they said that promotion, not being a matter of right, could have been rightfully denied in the year 2004, which was later on, yes, guaranteed or granted in your 2008. This is what actually came out of this judgment in Sushil Kumar versus State of Haryana. Moving to next, let's talk about the next judgment, that is Arunagandar versus Pannaswamy. Now, in this case, again, a crucial matter that had come up in the year 2019 was again spoken about, which was your right of the daughter to get a right in the property of the parents and exclusively the father. That is, if the father was dying without leaving a will behind. So without leaving a proper stated written down will. He dies without leaving a will, which is known as an intestate succession. Right? अगर ऐसा होता है, the daughter has equal and absolute right in the property of the father. Not just son, but even daughters have a right in the property of the father. This was now given a backdated effect in the previous judgment that have come in. So what has been held in that judgment was not only after the passing of the Hindu Succession Act, but even before that, where there are any cases. Here also, wherever the question regarding intestate succession comes in, at that point of time, even then the daughters will get a share in the father's property. Keeping that in mind, again this case dealt with that matter, that is, yes, the daughter will have a right in the that is, the daughter will now have the right in will have the right and will be entitled to inherit the self-acquired property of the father who's dying intestate, or of a Hindu male dying intestate. Another aspect that was discussed in this judgment was what happens if, for example, any property is being transferred. Property is being transferred to a Hindu female. It is being transferred to a Hindu female, but she dies without leaving any issue, and she dies without leaving any will behind, meaning she has no legal heir and she does not even leave a will behind regarding how this property will be dealt with. What will happen to such a property? In this manner, the property will be returned to who? The source of this property. So source will mean if it came from her parents, that is her mother and father, it will go to the legal heirs of the mother and father. If the mother and father are living, it will go back to them. If not, it will go to the legal heirs of the mother and father. And if it came from the husband, or if it came from your father-in-law or mother-in-law, then it goes back to that source. So the legal heirs of the husband, the father-in-law, mother-in-law will become the heirs to this property. That is how what all was discussed in this judgment. Moving to next, we are going to talk about State of UP versus Jaidath. Here, the concept of Section 302 of IPC was discussed. Section 302 of IPC deals with the punishment in respect of murder. Now, please remember, whenever we are talking about murder, we are always talking about intensified and aggravated forms of deaths. Okay? So basically, culpable homicide not amounting to murder under section 299 and murder under 300 can be differentiated on the aspect of the intention and the gravity of the offense. Now here in this case, what had happened was a person, let's assume this person is X, he had given a wound to the deceased, meaning the person who died. He had caused an injury to him on the head. Now what had happened was this injury went unnoticed at the time of death. So they could not infer from where exactly this injury was caused or what exactly was the cause of death at that point of time. So what had happened was they held this person guilty under section 326. So he was given the punishment for causing grievous hurt. However, an injury on the head of a person which leads to the death is an injury that shall be counted as an injury on the vital part of the body. The moment there is an injury on the vital part of the body, knowledge for causing the death of the person is presumed. अब इस presumption के अंदर we cannot rightfully punish that person under section 326. We must punish him under section 302 of IPC. This is what was held under this judgment, that the mere fact that there was no fracture that was noticed or which could not be found, here a punishment under section 302 was yet to be given, because it was later on found that the deceased died due to a head injury. 326 cannot be rightfully imposed here. The correct imposition shall be of section 302 of IPC. Moving to the next judgment, we have Shain Begum versus KK Rathinawal. Now over here, in this case, the concept of specific performance under the law of contract was discussed. Now over here, the Supreme Court had held and observed that the conduct of the plaintiff, that is our complainant, is crucial in the suit for specific performance, and the same has to be assessed by the courts. They also said that it is not only necessary that we should see the financial capacity of the person to pay, but we must also look at the conduct of the plaintiff. What had happened in this case was that the parties, let's say assume A and B, had entered into an agreement in almost 3 decades back. That is almost 30 years back, they entered into an agreement of sale. Now the plaintiff, after 3 decades, he wants the specific performance of that agreement on the same price and the same value as it was 30 years back. Now understand, concept of inflation naturally means that the price of the property increased immensely in 30 years. So if we were to say, enforce this or specifically enforce this contract, then it would naturally be a wrong or injustice to the defendant. So now over here in this case, noting that this 30 years gap between the filing of the cases and the actual result was absolutely unjust. So here they did not grant specific performance. However, they said if there was any consideration that was exchanged between the parties beforehand, must be returned to the plaintiff with a specific interest value. This is what was held in this case. Moving to next, we have Brijesh Chandra Dwivedi and his legal heirs versus Sanya Sahayak. Now here in this case, what happened is that there was a case of dismissal. Dismissal from service on the ground of driving under the influence of alcohol. Now this person who was a driver under this organization, he was driving under the influence of alcohol. He had met with an accident, and then upon that accident, what had happened, a departmental inquiry was conducted. In this departmental inquiry, he was now dismissed from his service. Now his legal heirs had now claimed that it was a minor act. He was driving under the influence of alcohol, but there was no major consequence, no major accident. Hence, a dismissal was not appropriate. In this case, the Supreme Court has clearly taken a stand and has stated that while dealing with the case of an employee's dismissal from service after being found guilty of driving under influence of alcohol, the Supreme Court has observed that merely because there was no major accident occurred, leniency can't be shown for the misconduct of drunken driving. So this is now the stand of the Supreme Court, that even though here it's a minor offence, yet it is absolutely an offence. Another thing that was stated was nobody can be permitted to drive the vehicle under the influence of alcohol. This is not just a misconduct, but it is a clear offence in the eyes of law. So, departmental inquiry, and upon the result of this inquiry, dismissal from the service was held and was upheld. So, a appropriate punishment was allotted after this. However, because the person now who was dismissed, that is Brijesh Chandra Dwivedi, had passed away, he had died. Now, in this case, the Supreme Court had, yes, shown some leniency. They said that dismissal, however, would be a very extreme step. We shall, turn this into a compulsory retirement so that his legal heirs can get the pension benefits from this. This is what was held from this judgment. Moving to next, that is State of MP versus RD Sharma. This judgment basically gave us a statement regarding equal pay for equal work. Now, equal pay for equal work is a directive principle of state policy under your Article 39 Clause D of the Constitution. Now, a vision, an objective of the Constitution given under Article 39D was enforced through the Equal Remuneration Act in India. However, the court has now said that the equal pay for equal work is not a fundamental right. Yes, we agree it is a legal right, but it cannot be guaranteed. So, it's not a fundamental right vested in any employee, though it is a constitutional goal. It is an objective that, yes, we do wish to achieve in the near future. But as of today, yes, it is not, or it does not have the status of a guaranteed enforceable fundamental right. The bench had further stated that the equation and post of determination of pay scales is the primary function of the executive and not the judiciary. That is, the enforcement of these rights is the activity of your executive. The judiciary cannot come in and have a role in this regard. So, ordinary courts will not enter upon the task of job evaluation, which is generally left to expert bodies such as the pay commissions and so on. This is what was the wording of the court in this judgment. Now, moving ahead, let us talk about some important events that have happened in the second half of January. Starting with, there is a draft notification on the 6 mandatory airbags for every vehicle. So, Union government has now started the process of initiating that every car must now come with 6 airbags. Now, please remember, as now this actually has not yet been implemented. Please note that these are draft notifications. They have been put out in the public so as to get some sort of a feedback from the public and the stakeholders, that is the companies now that are going to be involved and affected by these. So we are now inviting, that is the government, the union government has now invited the comments from these two entities before they finalize these notifications regarding 6 mandatory airbags in every car. So what is an airbag? Naturally, airbag is nothing but a vehicle occupant resistance system using a bag. So basically, an airbag is used so as to prevent any impact and to save lives in the matter where there is an accident. So they are fitted in cars for providing the vehicle occupant with a soft cushioning and restraint during a collision. So these are measures to prevent and to save lives wherever there is an accident of any sort. Moving to next, the extension of National Commission for Safai Karamcharis has now been increased for another 3 years. The National Commission for Safai Karamcharis was established in the year 1993 under the National Commission for Safai Karamchari Act 1993. It has been getting regular extensions by the Union Cabinet in this regard. Now, what is the basic purpose of your commission for National Commission for Safai Karamcharis is basically it is an advisory body. So what does it do? It looks at and it recommends various things to the central government for the safety, security, provisions in respect of your Safai Karamcharis. That is what is the working of your NCSK. Okay? Now, another thing that you have to understand is that the very important prohibition of employment as manual scavengers and the Rehabilitation Act is monitored under this commission. So this is a very important fact in respect of all of your examinations. Do ensure that you go through this. Moving to next, the change in the spending norms for the contingency fund. Now the contingency fund of India is what we are going to be talking about over here. Now, in this budget of 21 and 22 had clearly said that the contingency fund shall be increased from rupees 500 crores, that is the existing amount, to the rupees 30,000 crore. Now, next provision in this regard is, as per new norm, an amount equivalent to the 40% of the fund corpus has to be placed at the disposal of the Secretary of Ministry of Finance. What for? To meet any unforeseen expenditures such as we had faced COVID. So this is a fund that is now going to be used at the time of any emergency or any sort of a urgent situation that the country has to deal with. 40% of the expenses of this fund shall be at the disposal of the Secretary of Ministry of Finance, and beyond this 40%, all other contingency fund releases has to be made with the approval of the Secretary. Please remember, this has been done with the appropriation of your finance bill. So one important aspect that all of you should study is the finance bill. Moving to next. India has recently commemorated its 73rd Republic Day on 26th of January 2022. It is the 73rd Republic Day. What does this day stand for? What is the meaning of this day? How is it relevant for all of us in the legal field? Now please remember, 26th of January 1950 is the day when your constitution is commenced. It comes into force. It now becomes applicable throughout the country. It is also the day where we had, under 26th of January 1930, celebrated the Poon Swaraj Day. To commemorate the importance of this day, finally the constitution began on and it commenced on the 26th of January 1950. Now another thing that you should remember in this regard is that this day clearly gives out our Republic Day. So, if you ever get a question in your examination, that is, when was the country declared as a republic, it was on 26th of January 1950. Please note that from 1947 up until this date, we were a dominion of the British. It was only after this date that we became a republic. A republic is nothing but a country where the head of the country is a elected representative, not a hereditary monarch. Keeping these points in mind, this is how this day is relevant for all of us. Moving to next, the Lok Sabha Secretariat launched the new app Digital Sansad. This was launched on January 27, 2022. Now, the app was launched to make it easier for people to follow the proceedings in the parliament and the lawmakers. So, what is the name of the app? This is Digital Sansad, and with the purpose of following the proceedings of the parliament and the lawmakers of the country. Finishing this off, let's talk about some of the international events that have taken place in the second half of January. Number 1, Aisha Malik becomes the first Pakistan's Supreme Court judge. So first female Pakistan's Supreme Court judge, Aisha Malik is the name. Important pointers for your exams. Second, Kazakhstan has a new Prime Minister, Alikhan Samailov. Moving to next, Novak Djokovic was deported from Australia as he did not take the COVID vaccine. Now, please remember that we had been following this case prominently at this point of time. He had gone in for the Australian Open. However, he was denied entry and was deported from the country on the grounds of threat to the public health and public order. So, health, two grounds on which he was deported was health and public order, right? So this is something that, yes, was quite an entertaining perspective that all of us were watching, and eventually, yes, the final result of the court was that he was going to be deported. Lastly, here, Australia's Online Safety Act came into effect. Now, Online Safety Act of Australia is an act that deals with online bullying. So, online bullying is basically the act by which multiple people may target one person, or not just multiple, even if one person targets another person and harasses him continuously or conducts bullying through an online medium. Could be by posting a picture, could be by posting certain comments, or could be by sharing any sort of comments on the your various online platforms. Here, by this act, now a very strong perspective has come in the respect of mental health development across the world. Now, in such a case, the power is such that the complainant can directly approach the e-safety commissioner and for filing the complaint in this regard. So it's a very important act. If you're asked about this, you now know that what does this act deal with. Moving to last perspective for today. Now we are going to talk about some important days that came in the month of January. January 24th is the National Girl Child Day. National Girl Child Day basically commemorates the importance of the protection of girl child in the country. So, various legal measures and policies have come in for bringing in awareness as well as the protection of the girl child in India. Next, January 27th is celebrated as International Day of Education. Now, when you talk about education and the rights in this regard, do remember that we have a Right to Education Act in India. We also talk about Article 21A that provides the fundamental right of education to children between 6 to 14 years. We must also remember Article 45 or DPSP that provides for the care of the child below 6 years. And then Article 51A, Fundamental Duties, K-th duty or the 11th duty deals with the duty of the parent to provide care for the child between or provide the care for his child between 6 to 14 years. Now, understanding all of these, the aspects of education in India are such. Lastly, we are going to be talking about the National Voters Day that is celebrated on January 25th. Very important from exam perspective. Now, understand some of the major rights that are going to be spoken about over here. Firstly, Article 326 of the Constitution gives to us the concept of universal adult franchise. Universal adult franchise states that any and every person of 18 years and above has the right to vote in India, and he can only be denied the concept of vote on certain exclusive grounds, such as unsoundness of mind or criminal cases against such person and so on. So 326 provides the concept of universal adult franchise in the Constitution itself. But always remember and note that right to vote is not a part of your constitution. It is, yes, derived from article number 326, but it is given under under section 62 of the Representation of Peoples Act. This is the basic right of vote. Some other important points. Who can vote in India? Firstly, such a person shall be a citizen of India. Secondly, he must be at least 18 years of age. So, minimum age is 18. This age was earlier 21 years but was reduced by your 61st Constitutional Amendment. And lastly, he shall be of sound mind. Keeping all of these provisions in mind, do ensure that you read up something on the concept of voting in India because of the upcoming elections that are coming in the country. Now that is all for today. For more such videos and more such sessions, come and join us on YouTube under the channel HitBullsEye. Thank you.